Okay, good morning, everyone, and welcome to the ins and outs of employment law for the nonprofit leader. This panel is brought to you by the Cleveland Metropolitan Bar Association's Nonprofit Legal Resource Center, and my name is Samantha Larson. Those of you who attended November's forum heard me flag several legal issues that deserve the attention of every nonprofit leader, and our panelists today will dig more deeply into several of these, sharing their expertise and practical tips. I will leave it to our Master of Ceremonies to introduce our panelists, but it's my pleasure to introduce our moderator, Attorney Josh Selby. The legal profession is a second career for Attorney Selby, who worked for 8 years as a critical care nurse before attending Cleveland State University School of Law. And his medical background makes him uniquely qualified to interpret medical records, a skill that he applies to his workers' compensation practice. In addition to giving us his time today, Attorney Selby volunteers through CMBA's 3Rs program and has worked at Legal Aid Society of Cleveland on alleviating poverty and expanding access to healthcare through MedWorks locally and as far away as India through International Volunteers HQ. Attorney Selby is the founder of J. Selby Law and a member of the Cleveland Legal Collaborative. Without further ado, I will pass the mic to him.
All right, good morning, everyone. Welcome to the panel. Today's panel brings together three very experienced employment lawyers who approach workplace issues from different perspectives. Let me briefly introduce the three panelists. First, Claire Wade is a founding partner at Selby Wade and Mapley, where she focuses on plaintiff side employment discrimination, pay equity, harassment, and retaliation. She regularly practices before the EEOC, the OCRC, and in state and federal courts, giving her a clear view of employment pitfalls organizations must avoid. Claire is a cum laude graduate of SMU Dedman School of Law. Matthew Besser is a principal at Bullock, Besser, Glacius, concentrating on employment discrimination and civil rights matters. With experience on both the plaintiff and defense sides, as well as working as an employment arbitrator, he brings a practical perspective on how employment disputes arise and how they can be prevented. Matt is a summa cum laude graduate of OSU Moritz College of Law. And finally, Jennifer Corso is a partner at Patronzio Schneer, where she advises and defends employers in labor and employment matters. Her practice focuses on compliance, investigations, policies, and day-to-day employment counseling. Key issues for today's panel. Jennifer is an OSBA certified labor and employment law specialist and a graduate of Cleveland Marshall College of Law. I think now we can move to our presentations, and I believe Claire will go first. Brief disclaimer on the screen there. No attorney-client relationship is created today by this advice. It's not formal legal advice, and you are welcome to contact us as a follow-up about any of this information. Claire?
Okay, thank you, Josh. Good morning, everyone. My goal here this morning is just to provide a brief overview of some of the major employment laws. And after we go over those, then we'll have Jennifer give us kind of a proactive approach on how to deal with these laws through the employee handbook and other avenues. And then Matt will have a turn telling us what to do if an issue does arise, if someone requests an accommodation or complains about discrimination, things along those lines. So the first thing to keep in mind today is that employment in Ohio is at will, like it is in most states. And that just simply means that an employee can be terminated at any time for any reason or no reason at all. My favorite example is to say you can fire one of your employees for being a Cleveland Browns fan, right? You don't have to have a good reason. But there are some exceptions to at-will employment. The biggest one that we deal with are the anti-discrimination laws, right? So these are the laws that prohibit discrimination in a hostile work environment based on age, race, gender, national origin, and disability. These are what we call our protected classes. If you go back one, please. Thank you. So these anti-discrimination laws include Title VII, which you are all probably familiar with, the ADA, the ADEA, and then the Ohio Revised Code 4112, which is the Ohio equivalent of Title VII, ADA, ADA. So these are the laws that bring us here today, right? So unless it's contrary to one of these laws, you can fire someone, basically. So the things to keep in mind with respect to these anti-discrimination laws is they only cover these protected classes. When we say protected classes, we're talking about age, race, gender, national origin, and disability. Other classes aren't protected, right? So we're not talking about nepotism. We're not talking discrimination based on other interests. It has to be falling in one of these specific categories. Title VII, the ADA, only cover employers with 15 or more employers or employees. But Ohio's code covers those with 4 or more employees. And not included in this presentation, there are actually local laws that cover people with only 1 employee. So these anti-discrimination laws cover hostile work environments, right? But a hostile work environment isn't just someone being mean and yelling and slamming doors and whatnot. That's just someone being a jerk. When we're talking about a hostile work environment, we're talking about unwelcome conduct based on one of those protected classes, right? And that conduct has to be so severe and pervasive that it interferes with that employee's job, right? So a single comment, unless it's very extreme, isn't going to rise to the level of a hostile work environment. Another kind of definition we should talk about is protected activity. So if someone opposes discrimination or hostile work environment based on age, race, religion, sex, etc., that's considered protected activity. But just a complaint that someone's mean or a jerk, yelling, slamming doors, that would not be protected activity unless the underlying action was based on one of those protected classes. Right? We hear that a lot. People complaining, I'm being retaliated against. I complained that my boss was mean. Well, it's not unlawful retaliation unless that complaint was related to one of those protected classes. And retaliation is really one of the biggest and most frequently alleged bases of discrimination, right? And examples of protected activity would be if someone files an EEOC charge, if someone complains about discrimination, or if someone says no when they're being sexually harassed, or if someone's asking for accommodations for a disability. Speaking of disabilities, the ADA and the analogous Ohio statute require that you provide accommodations for disabled employees. Now, Matt will get into more specifics, what to do if people request accommodations and whatnot, but know that the ADA does provide for accommodations in the case of a disabled employee. I'm still on the previous slide. If you go back, Sam, thanks. So an accommodation is available for disabled employees, and that's for something that would make their job easily for them to perform with their disability, right? So they need to be able to perform all of their job duties with their disability with the accommodation. The basic example is your cashier at the grocery store, right? They don't need to be standing up to check you out. And if they have a disability that requires them to sit, it's easy enough to provide that accommodation. You provide the cashier with the stool, they can sit and they can perform the essential function of their job, right? Checking out customers. Josh, do we have some questions?
Yes, one question just came in. The employee numbers in column three, does that count only full-time employees or does that a total of full-time and part-time employees?
So it's going to depend on your payroll, and you look at, your payroll during the year. So it will count part-time employees as well.
Okay.
And with disability, there's also a thing called an associational disability. So if your employee has a close family member, such as a child or a spouse with a disability, you could be required to accommodate, you can't be required to accommodate that disability, but you could just potentially discriminate against that employee based on their relative's disability, right? So if you think, oh, my employee's child is disabled, so they're not going to focus on their work, let's get rid of them. That's the context and what that comes in. So if we could go to the next slide. Recently, the PUMP Act and the Pregnant Workers Fairness Act were passed. And the important things about these are that the PWFA provide for these similar accommodations for pregnant workers that we already had for disabled employees. So previously, if a woman, needed to sit down because she was pregnant, but not because she was disabled, that wouldn't be considered an accommodation for her pregnancy, right? Now, anything related to pregnancy should be accommodated. These include doctor's appointments, sometimes a flexible schedule if the woman's experiencing nausea in the morning, time off for delivery, time off for an abortion if it's required. So those are all covered. And then we have the PUMP Act, which now provides that employers have to provide this space for pregnant or lactating employees for up to a year after childbirth, right? So unless you have a significant difficulty expense providing this space, all employers, irrespective of how many employees they have to provide this for their lactating employees. But this is only for 1 year following the birth of the child. So if an employee is hired while they are currently lactating, you would need to accommodate that up until that 1 year mark.
Claire, I have a question for the PWFA. What kind of documentation is the employer allowed to ask for in order to be required to provide these accommodations?
I would think for pregnancy accommodations, most of them are going to be pretty obvious, right? So if, a woman is having doctor's appointments, you would be able to have, notes for those appointments, but, other accommodations, depending on what they were, you might need additional notes or not. Matt will get into all those details as far as when someone does come to you with these requests, what to do. Okay, and so three other things I just want to touch on pretty quickly are the FLSA, which all of you are familiar with, whether you know it or not, because that's what provides for minimum wage and overtime. And I don't want to get into the weeds here because we could spend 3 days talking about just the FLSA, right? So the things to keep in mind with respect to the FLSA is that everyone has to be paid minimum wage. And unless they're exempt, you have to pay overtime for all hours over 40 worked in a week. Like I said, I could spend all day talking about the FLSA and the exemptions, but for purposes of today, I think that's enough detail. And then we have FMLA. This is what provides for your job protected leave. Most people think of this as maternity leave, right? The most commonly thought of, a woman delivers, gets to take those 12 weeks of job protected leave. But it also covers other health conditions if you need to go out for surgery, caring for family members. Now, FMLA is up to 12 weeks of leave per rolling calendar year. So If someone takes 12 weeks of leave for a health condition, they have to wait for those 12 weeks to fall off before they can take FMLA again for another condition. You don't get to stack FMLA for different conditions. And there's also intermittent or continuous FMLA. So an employee can take FMLA only a few days per month versus continuously until they return. And then finally, briefly, we mentioned that Josh practices this workers' compensation retaliation. Now, all your employees, I believe, should be covered by workers' compensation. And where this comes up is if one of your employees gets injured, um, applies for workers' compensation, and then you take some kind of adverse action against them, whether it's, reducing their pay, reducing their hours, or terminating them, then that would set up a potential workers' compensation retaliation claim. And then one more thing I want to cover before I turn it over to Jennifer is touching on this idea of an employee versus an independent contractor. Um, And the reason this matters is all these laws I was just talking about apply to employees, not independent contractors, right? You don't have to pay independent contractors overtime. You can discriminate against your independent contractors. I'd rather you didn't, but under those laws, they would not apply. Um, and then, we have other things like ERISA and other things that would apply to employees, workers' comp. So how do you choose when you hire someone? Do I want to make them an employer independent contractor? Well, you don't really get to choose, right? It's the nature of the job that chooses for you. You really have to look at the job and make the determination whether that individual is an employee or an independent contractor. So the things we'll look at in determining whether someone's an employee versus an independent contractor is, how the work is done. Are you telling the employee when and where to do the work, how to do the work, giving the individual the tools to perform the work, right? We have our quintessential test or examples, the plumber, right? You hire a plumber to come in and fix something broken at your office, right? You don't tell the plumber what tools to use, how to fix it. You just tell them, hey, fix it, right? They're an independent contractor. But when you start bringing in employees and telling them, hey, for example, home health aides, right? If you tell them, go to this location and take care of this patient from this time to this time, and then go to this other location from this time to this time, you're starting to exert enough control and telling someone what to do that they're going to start looking like an employee instead of an independent contractor. So
Claire, one question, just to be clear, is there any controlling effect with regard to what is stated on the employment offer or the employment contract? If it says in big bold letters, independent contractor, does that control at all?
no, because we need to look at the actual facts and circumstances of the nature of the relationship, right? We can call someone an independent contractor, but if they're performing, the duties as you're telling them and when you're telling them and wearing your uniform, well, they sure the heck look like an employee then, right?
Right.
And that was one thing also I didn't mention in the beginning. We're talking about, employees at will. That changes a bit if we have an employment contract, as Josh mentioned. But an employment contract isn't an offer letter, right? Sending out an offer letter saying, hey, we're going to give you this position, this salary. That's not a contract. Talking about an employment contract. We're talking about we're going to hire you for a term of, 1 year or X number of months, pay you this rate, from this time to this time. That's a contract. So if you have an offer letter, that's not the same thing. So knowing all that these laws apply, what do you do? How do you keep people, keep your team from running afoul of these laws and making sure that you're treating your employees fairly, consistently? Jennifer?
Thank you, Claire. Yes, so that's the question for the day. So how do I know, how do I make sure that everybody is following the rules, knows the rules and follows the rules? And that leads into my discussion of employee handbooks. Um, I am a big believer in employee handbooks. I know that there are some attorneys out there, not employment attorneys, who try and tell employers, you don't need an employee handbook. You're too small, or you don't want to write things down because that will hem you in, and things of that sort. I don't believe in any of that. I've been doing this for over 30 years, always working with small businesses, for profit and nonprofit. And I truly believe in employee handbooks for even the smallest of organizations. Um, Bottom line is, so many of the things that cause an employee to, you know, be dissatisfied in their job, to go and seek counsel and talk to somebody about, you know, do I want to sue my employer? Is the feeling of being treated unfairly. You know, I say this in a lot of my seminars, and I only say it half jokingly, but happy employees don't sue you. So trying to keep people um, happy at work, really the essence of that is being fair. And when it comes to the rules, if you don't tell your employees what the rules are, and if you're not following the rules equally for everybody, then that is what can lead very, very quickly to feelings of dissatisfaction, to being treated unfairly, and somebody not liking where they're at. And then, you know, if something happens, if you don't follow the letter of the law, and you know, then that's where employee lawsuits can easily originate from. Um, so employee handbooks. First thing, do not get your employee handbook from ChatGPT. All right, I can't say that strongly enough. That's not the place to go. So for employee handbooks, here's sort of my little list of important considerations. The first one is really very important. You need your handbook customized to your organization. If you're an HR person who, you know, if you're a nonprofit, and let's say you're a nonprofit that works somewhere in the social services agents, you know, maybe, you know, helping foster children or the unhoused or something of the sort. If your HR person used to work for a manufacturing company and brings that employee handbook along, it is not going to speak to what you need it to speak to. All right. So make sure your handbook is customized to your organization. Make sure that it is up to date and current with your practices. The key part of an employee handbook is you've got to walk the walk and talk the talk with an employee handbook. You can't have a policy that you're just not enforcing, or even worse, selectively enforcing. Again, that's where people feel they are being treated unfairly, and that leads to the employee dissatisfaction. Make sure it covers everybody. Some places only have handbooks that cover one area, like the non-exempt employees, and they don't have ones that cover managers. It's never made sense to me. You know, a handbook should cover everybody. If you are such a unique organization that you feel you need different policies for different segments, great. We can break that down within a handbook. All right. Um, I'm gonna go back, please, for a second. Um, go. So, um, one thing is, do you have any out-of-state employees? All right. Handbook policies are very state specific. Make sure that if you've got any people working out of state, even remotely, you know, that you make sure you are speaking to them as well. Especially, please, if you have anybody out of California. There are a number of hoops you have to jump through for California policies. But make sure that you are considering anybody out of state. Same thing if you have people working remote, even in state, even locally. If you have remote employees, you want to address that within the handbook. Finally, you know, make sure that your handbook, if it's not created by an attorney, it is legally reviewed. Now, big disclaimer here. You could line up a dozen or 2 dozen HR consultants and employment law attorneys and ask every one of them to create an employee handbook for your organization. I'm going to guess 70 to 80% of those handbooks are going to be very much the same, if not identical. But it's that remaining 20-30% is what I call, this is more art than science in the world of law. Okay. For example, when I do handbooks, I don't like fluff in there. I want to cut straight to the policy. I don't need all the nicey language. I don't need language saying sexual harassment policy. The purpose of the sexual harassment policy is to prevent sexual harassment. Yeah, I think we got that. So I just like to streamline. But some people like the fluff. Some people like graphics. Some people like, a lot of different things in handbooks. So you can get different handbooks from different sources. It doesn't mean that they're wrong. As long as they are complying with these considerations, you're in good shape. Okay, next slide, please. So, what do you need to have in a handbook? Now, I'm only listing, not even 10 policies here. You're going to have, a couple dozen policies within your handbook. But these are key legal ones that I want to see, both from law as well as HR best practice standpoints. Of course, employment at will, just like Claire said, we have it written in our job offer letters. We have it written in the disclaimers in the handbook. We have it written a couple different places, but yes, we can't say it enough, and that's a legal issue to have in that handbook. EO policies, anti-harassment discrimination policies. I want every one of my clients to have this type of stuff here in there. Matt's going to discuss this a little bit, but I want everybody to have an accommodations policy. Now, if you are less than 20 employees, it doesn't necessarily have to be an ADA accommodations policy because ADA only hits, 15 employees. But you still want a policy that speaks to accommodations, whether it's disability, religion, breastfeeding mothers, things of that sort. Same thing with the medical leave of absence policy, and I'll touch on this just in a few slides as well. Finally, have an open door policy because that's a catch-all. It's basically something that says, hey, if you got a problem, here's the reporting structure we'd like you to use. And here's an alternative reporting structure just in case the first one doesn't work for you. It just grabs everybody in. Nobody can then say, I didn't know what to do. Okay. Next slide, please. So I'm going to talk about a few of these policies really quickly. And just like Claire said with FMLA, I could turn any one of these into a day-long seminar. So we are going just very, very brief. For your anti-harassment discrimination policy, always have multiple reporting options, okay? Only the smallest of organizations really can't do that, but if you can, please do. Since you guys are nonprofits, you probably have a board. You can always have the board be one of your reporting options. They should not be the first, okay? But they could be an alternate or somebody specific on the board, for example. You always want to include anti-retaliation provisions. And this is pretty much in any type of policy, whether it's your accommodations, EEO, anything like that, workers' comp, always have an anti-retaliation policy in there because the laws provide for it. I'll speak to training a little bit later, but you absolutely want to train both your employees and your supervisors on the anti-harassment discrimination policy. I believe in handbook training in general and training employees, not on, you don't have to read the handbook to them, but going over the more important policies, but especially ones with reporting structures. But this is actually what we call an affirmative defense. So if somebody gets up, leaves, and 2 months later, you get served with a lawsuit and they say, I've been harassed or discriminated against every day for the last 3 years on the job, and nobody did anything about it. If they've never reported it, if they didn't follow your reporting structure, okay, then you may be able to say to the court, they didn't do what we asked them to do, what they were instructed to do in the handbook, and therefore we can throw this lawsuit out. Now, I'm very much simplifying things here, but that's really the essence of it. And training the employees is part of that process. You have to jump through a few hurdles. All right, next slide. So on the job injuries and accidents, one of my pet peeves, and this is just me, I hate it when I see workers' compensation listed as a benefit in an employee handbook. It's not a benefit because it is not optional. You as an Ohio employer must be paying into the Ohio Bureau of Workers' Compensation and providing your employees with workers' compensation. Okay, so it's not a benefit as I see it. So I always title things on the job injuries and accidents because strangely enough, not every single on the job injury might end up being a workers' comp claim. So I prefer this title, and it's picky, but that's how I am. Um, so one of the big things here is we want to make sure that we tell employees you need to report an injury immediately. Okay. Employees used to have 2 years to report injuries. Now it's down to one. But still, it's very hard to disprove a claim if somebody waits weeks, months, sometimes even days. Witnesses are crucial to these things. So you want in your policy that immediate reporting is required whenever it's possible. All right. And again, offer an alternate reporting structure. So report things to your immediate supervisor. If they're not available, here's who you go to. Of course, if it's a serious injury, somebody's calling 911 first. You're not looking for the supervisor around a manufacturing plant while somebody's bleeding out. We're calling 911 first. But these are the essences of this. All right, next one, work conduct. So this is another big policy. This is basically your disciplinary policy. What I like to see in handbooks is what I call a laundry list, a bullet point of maybe 10 or a dozen big concept issues. So things like, job document falsification or insubordination, or even though we have a harassment policy, just stating harassment, big, broad terms that provide a catch-all, basically, for maybe what an individual policy doesn't specifically address. Okay. Again, this needs to be tailored to your workplace. So, for example, if you are a nonprofit that deals with anything medical, you may have specific policies. You should have specific policies on patient confidentiality. All right. And so within your catch-all, you may want to have a backup that says something like violating patient confidentiality. You might have a HIPAA policy, but what if it's something that falls outside of HIPAA? So you want to be able to have this broad language within this laundry list. I also like saying, having that catch-all. Anything, any violation of any policy may lead to disciplinary action up to and including termination. So again, it gives you wiggle room. All right, next one. Medical leave of absence. So if your organization is too small and does not fall under the FMLA or the ADA, I still highly recommend you have a medical leave of absence policy. My recommendation for all employers that aren't covered by FMLA is 6 weeks. Reason for that is from a practical standpoint, if somebody needs a 3-week accommodation and you say, oh, we can't possibly be without you for 3 weeks, so you're fired and we're going to hire somebody in for you. You're not going to get somebody in 6 weeks, in 3 weeks. You're not going to get somebody in 4 weeks. Usually, by the time you post, interview, somebody gives their notice, you get them in, they get up to speed. If you can do that in 6 weeks, you're doing really well. Okay. So in most cases, there's really no reason not to approve up to a 6-week leave of absence. There's also things in the Ohio Administrative Code regarding absences for childbirth, and that's a 6-week rule. So I just modify it to them. Again, you want an accommodation policy that covers several different accommodations. Disability, religious, nursing mothers, any type of accommodation. Okay. Just because somebody asks doesn't mean that you're required to give it to them, but under certain laws you are. Okay. And then again, make sure that your leave of absence requirements, that they have a request procedure involved in it, and that you include all of this within both your employee and your supervisor training. Next slide, please. So this is just a little best practices. Like I said, be very careful where you get your handbooks. Don't grab them just off the internet. Most of those, strangely enough, they come from California, and California has very weird employment laws, so you don't want those. Do not grab them off of ChatGPT. Do not grab them from your old employer. Make sure it's customized for you and make sure that there is legal review on it. Next slide. Let's talk about updating. So you have a handbook, but you haven't looked at it for a while. It hasn't been touched or updated in several years. Yes, you definitely want to take a look at that and see, does it still comport with what you're doing? Do your policies match your actual procedures that are in place? Okay. Are there legal changes like Claire was talking about? Do you recognize the Pump Act, the PWFA, things of that sort? If not, it's time to update your handbook. Has your organization grown or shrank? Maybe there's new laws. Maybe you no longer have to be under the FMLA. And again, location of the organization, where your remote employees are. So you want to make sure you're looking at these types of situations. Um, who is involved in an update? Sometimes in a small organization, it's just your CEO, the owner of the business. Okay. If you've got a board, sometimes the board gets involved. Sometimes people like to create employee committees to be involved. There's no right or wrong answer to that. It's what works for you. But again, make sure that you are involving a high level HR consultant or somebody who is very well trained in HR or having legal counsel review it as well. And last slide, please. Training. Guys, I can't stress this enough. All the policies in the world don't do any good if people aren't trained in how to follow them, especially your supervisors. Okay. You want to make sure you are educating everybody in your organization about what your policies and procedures are. This is huge for risk reduction. Okay. That's number one thing on my list as representing management. My first job is to keep you from getting sued in the first place. If my clients never get sued, I feel I'm doing my job a lot better. Okay. But if something comes along, whether it's a workers' comp, unemployment, EOC claim, or a lawsuit in state or federal court, if you have all this in place, this is your defensive toolbox, and training is part of it. You can say, we trained our employees. I don't know why they didn't report X, Y, or Z. I didn't know why they didn't report their supposed workers' comp claim for 4 months. It's in the handbook, but we also train. They were in the training session. Here's the list. There's their signature, all that. In addition, you want to train your supervisors. When I do employee training for clients, I come in, I talk to the employees about handbooks, discrimination, workers' comp reporting, things like that. And then I have the supervisors stick around. Okay. Could be another hour, could be another 3 hours, depending on the client. And then I talk to them what Matt's going to discuss next, what to do if. So supervisors don't know this instinctively. Okay. And mostly, unless you're taking like MBA level courses, nobody's teaching you this in school. So you want to make sure that your supervisors know they are your first line of defense. They are the ones who are most likely to unintentionally or intentionally violate the laws. So you want to make sure that they have all the education needed. Um, and that is it for me. So,
Jennifer, I have maybe a basic question, but
mhm.
employee handbooks, are we still giving out printed copies in this day and age? How do we handle this?
Doesn't matter. Whatever the employer's choice is. If you have an employee portal on your website or something like that, that everybody can access documents digitally, sure, digital is absolutely fine. You don't need to kill a million trees on this. But you just want to make sure that everybody has received. You don't want somebody who says, oh, well, I didn't know how to use that, or I don't have a computer at home, or it's been broken for 6 months. So whenever you update, if you do distribute electronically, make sure you inform employees if anybody needs a hard copy, here's who you talk to.
Okay. And then the same thing when with updates, how do you disseminate? Do you have all the existing employees sign an update form,
Yeah,
acknowledge receipt?
absolutely. Whenever you update in, from a broader standpoint, if it's just adding a single policy, they can acknowledge that policy. But if it's a true employee handbook update, then yes, you want to have everybody sign off on the acknowledgement forms that's at the back of every handbook saying, I've received this update as well.
All right, sounds good. All
Thank
right,
you.
up next we have Matt Besser, who will answer the question, how do I respond when there is a problem? Matt?
Well, hey everybody. Matt Besser. I'm one of the founding principals of Bullock Besser Iglesias. I also happen to be the immediate past president of the CMBA, and I serve on the board with Claire. So, just on behalf of the board and the officers, thanks to everybody for being here. This is something new that we're trying, and we're really excited about it. It's a result of a lot of hard work, and we really hope to build an ongoing relationship and be a resource for you all. So let's see how we do today. Um, so let's scroll through the next slide and to the first slide. I'm going to talk about a couple different things here, but let's do it all under the umbrella of 7 basic key principles about how to respond to potential employment discrimination situations, complaints, or accommodation requests. And the first one's kind of obvious. You got to know the playground rules. If you're flying blind because you don't know the law, you better ask for help because employment law can be highly technical and even innocent mistakes can lead to liability. So understand the law, get legal help. As I said, we're here to be a resource for you when we can. Always got to respond. The next two, always respond and act promptly and consistently. These are both practical and legal. They're practical because, as I think it was Jennifer who said, uh, employees who feel that they are treated unfairly, those are the ones who are going to give you legal problems. As Jennifer, I know it was Jennifer now, she said employees who are happy, they're not the ones who are likely to sue you. So these two are important for a sense of fairness. They're important legally, as we'll talk about. You have some legal obligations in many situations to respond in harassment situations, in accommodation situations. You also want to respond consistently because inconsistent treatment, even if well-intentioned, can be used by smart plaintiffs' employment lawyers like Claire and myself to prove discrimination. Inconsistent treatment between employees who are similarly situated, similar in their job or situation. That is often the best evidence of discrimination or retaliation in these types of cases. So it's really important not only to be prompt, but consistent across employees. That's why you have to have good systems like a handbook and policies that you actually abide by. Next is investigate. When the complaint comes in, investigate it objectively, fairly, and promptly. No predetermined investigations. You shouldn't have the employee who was involved or accused of wrongdoing as the one who investigated. I tried a case a couple of years ago where the investigator was in the middle of trying to get a big promotion from the accused employee and got the promotion, right? So that wasn't a good investigation. It led to a jury verdict for us. Document everything. You already know this. If it's not written down, might as well have not happened. If it's not written down accurately, you will be sorry later. Again, one of the things that we look for on the employee side is inaccurate documentation, things that are written down untruthfully. That can often be evidence of malicious intent, and that's used to prove discrimination. That exposes you to liability. Confidentiality. This varies by situation, but in general, if we're not talking about an employee's medical information, which we'll cover in a minute, confidentiality as to investigations of alleged wrongdoing, harassment, for instance, it should be limited but not absolute. Share information only with those who have a real need to know. You can't promise absolute secrecy for some things. And lastly is don't retaliate. We've already heard that from Claire that this is one of the biggest sources of employment law claims. I think it's the single biggest source data-wise, according to the EEOC. So we will talk more about that as well. First thing let's talk about is sexual harassment complaints, because this is sort of the big ticket item. Let me give you a definition generally. So sexual harassment is generally defined as unwelcome sexual advances, requests for sexual favors, or other verbal or obviously physical conduct that is sexual in nature in the workplace. There are two legal categories of sexual harassment. Quid pro quo means this for that. That's the sleep with me or you're fired situation. And then what you've probably heard commonly referred to as hostile environment harassment. And this is the more frequently cited of the two. That's basically when the conduct is so severe or pervasive, right? So severe or ongoing that it has the purpose or effect of basically denying the employee's ability to do their job and creates a hostile work environment. Here we're talking about in the context of sexual harassment, but you can have hostile environment claims on any of the protected classes. You don't see them all that often for things like age, but you certainly could. You also see it for things like race, disability, pregnancy, and so on. Let's focus for now on sexual harassment. Under the hostile environment theory, most what the courts call petty slights and annoyances, a one-time offhand joke that isn't severe, one of the big slurs, um, a comment about someone's appearance. Most of the time, a one-off is not going to rise to the level of sexual harassment. So the courts are looking, as I said, for what's severe or pervasive. There's not a hard and fast rule on that. What there is a hard and fast rule on is that failure to act off by the employer when they know or should know that there's an issue is often what leads to liability. And as a plaintiff's employment lawyer, when a harassment claim comes in, one of the key things I'm looking for in determining is this a viable case is, did the employer know or should have known that this was going on and didn't stop it? And if we could just back up for 1 second, I skipped something real quick. So let me just give you some of the common examples of sexual harassment. Sexual jokes, obviously, remarks about appearance, exposure to pornography. In the race context, we will sometimes see racially offensive cartoons. I've seen cases where someone left a little noose on someone's desk, even a toy noose. And then the thing I really want to highlight for you today is that text messages are increasingly a common source of harassment. We see them in most cases involving harassment, but not all. And that poses some unique challenges for you in terms of data preservation, which is a little bit outside the scope of this, but it's something to look for, be aware of, to ask about. Okay, thanks. So there's a couple steps you got to follow when a harassment claim comes in. First, obviously, you got to make a plan. So that entails identifying who are your witnesses, deciding an order of witnesses, and then document gathering, right? So that might be emails, texts, things like that. In terms of identifying witnesses, you always need to investigate the complaining witness or the alleged victim, even if they're not the ones who complained, the accused, and then you want to identify any potentially corroborating or other involved witnesses. Once you finish your investigation, you'll make your findings of fact. You'll decide what your decision is. You're going to communicate the outcome. Let me just talk about communicating and findings of fact, and then we'll jump into how you interview these folks. Basically, you're going to decide, was there a policy violation or not? And that's pretty straightforward. Or can you not determine, right? Sometimes you're just not sure. I would advise you to use a more likely than not standard, right? Is it more likely than not, if I'm weighing out the scales, that this happened or didn't happen? The reason I advise you to do that is because if you get sued, that's the standard that the courts use to prove a violation. Is it 50.01% likely that this happened? And so it might behoove you to use that same sort of threshold when you're deciding whether to take action. And then communicating the outcome is you want to inform both parties the investigation is done, what the conclusions are, and if there's going to be any action taken and what it is. All right. So interviewing that should say interviewing complainants, but interviewing the complainant or in this case, the alleged victim. There's a couple things you want to do. You want to take an open mind. You want to approach it with an open mind. Don't come in with a predetermined conclusion. And this goes into fair and objective investigations. You want to let them tell their story uninterrupted. This is just good standard investigation and interviewing technique. Make notes as they're talking about points you want to come back to, and then you ask your clarifying questions, and you do it in a neutral way. You're not there to cross-examine them. You're there to find facts. You want to explain the anti-retaliation provisions, which we'll cover in a second. You want to make no promises about what outcome there's going to be. But you do want to ask them what outcome they're looking for. So lastly is consider the fear and the trauma response. And let me talk about this just for an additional second, because I think it's really important and misunderstood. For those of you who work in this space, you will understand about trauma response, and you will understand how victims of sexual assault, sexual violence, abuse, and other vulnerable populations might react to emotionally taxing situations. And one of the things that we see is that their behavior might not track what you would expect an otherwise credible person to follow. So, for example, in sexual harassment cases, it is quite common for the victim to blame themselves. And without having an understanding of a trauma response, you might see that as well. They sort of asked for it, and then dismiss the complaint. That's an enormous mistake, not only legally, but practically and probably morally. Another thing that we see is minimizing, right? Particularly if the victim, the alleged victim, is not the person who made the complaint. They might want to minimize or avoid this issue. They might not want to raise it because they're fearful of losing their job, or they're having trouble emotionally processing it. They want to avoid it. So you have to consider things like minimizing and avoidant behavior, or even what looks like evasiveness, lack of eye contact. You have to consider those in context. Those things could be evidence of a lack of credibility, but particularly in the context of vulnerable employees who may have been harassed, they don't necessarily mean lack of credibility. So if there's no question about that in particular, I'll just switch to how we interview the accused. You want to remind them of the non-retaliation obligation. Probably do that at the end. You want to explain the allegations neutrally. As with the complaining witness, you want to give them the opportunity to give a complete response. And then you follow up with your clarifying questions, but make no predeterminations with them too. They're entitled to a neutral, open approach, because you're trying to find the truth about what happened so you can decide what the employer should do. All right, so that's responding to harassment allegations. Let's talk about sort of the ADA in a nutshell, and I know we've covered some of this already. A disability, if you see on the left-hand side there, the box, is defined as an impairment, physical or mental impairment, that significantly limits one or more major life activities, or having a record of one, which basically means a history. So think cancer in remission, or multiple sclerosis in remission, or being regarded as having one of these qualifying impairments. So there, think about, for example, an employee who doesn't have an impairment, but maybe the supervisor assumes mistakenly that they have autism, that they are on the autism spectrum, something like that. That is a protected disability if the employer takes unlawful adverse action because of it. If we look over to the right, we see reasonable accommodations. We've talked about this already. One of the main ways that employers violate the disability laws is by denying reasonable accommodations. Reasonable accommodation is some modification to a workplace policy or procedure that allows the employees to perform the essential functions of the job, the basic job duties, not the tangential stuff, unless the employer can prove that the undue hardship exception applies. That's got to be something more than a small financial or operational headache. It's a high bar, and you ought to apply that bar, that exception to making reasonable accommodation very carefully and at your own peril. Because if you get it wrong, it's one of the hottest sources for liability in employment cases. So some common types of accommodations, the ones we see most often, modified job schedules, reduced schedule, right? Maybe you need a couple hours off a week to go to radiation, job restructuring, medical leave. This is a big one. I'll talk about it some more in a second, and then ensuring physical access to the workplace. So Claire mentioned a stool, that's one. A wheelchair ramp is a really obvious example as well. So if we can go to the next. So what do you do when an accommodation request comes in? First of all, you have to recognize it. There are no magic words required for an employee to request an accommodation. They don't need to say, I have a disability or I need a reasonable accommodation. All they have to do is make reasonably clear to you that they have some health situation and they need some modification to the way things are done. That's enough to trigger what's called the interactive process. And this is what you have to do when an accommodation comes in, request comes in, you engage in the interactive process. That is an informal back and forth between the employee, the employer, and sometimes their doctor to determine what accommodations might allow them to perform the essential functions of the job. So the first step in that is understanding the limitation. This is your information gathering stage. Claire mentioned this already, or alluded to it, in the context of the pregnancy discrimination question. You can ask for documentation about the disability and the need for the accommodation if it's not obvious. But if it's obvious, you can't ask for medical proof. If an employee is in a wheelchair, you can't ask for medical proof of why they need a wheelchair ramp. There are very, very limited circumstances in that scenario where you could ask for medical documentation, right? If you had a really super duper good faith reason to believe that they were faking being in a wheelchair. But that's a situation where you ought to talk to a lawyer first. In general, keep your requests for medical information about the condition and the need for the accommodation narrow, and avoid asking for a diagnosis if at all possible. There are circumstances, if it's not obvious, the need, you can ask them for additional documentation information from their doctor. There are even some scenarios where you can get a second independent opinion. But once you get to that stage, it's definitely time to be consulting legal counsel. Whatever medical information you get from the employee about their accommodation needs, right? Whether it's from them or their doctor, you have to keep it by statute in a separate confidential file that is not their personnel file. And there are very strict rules about who has access to that file, and it does not include the supervisor. So that information really needs to be sequestered out, and supervisors and others who wouldn't generally have a need to know should not be given that information unless they really do have a legitimate need to know. So you've gathered your information. Now, how do you determine what the appropriate accommodation is? This is where the back and forth might come into play. A reasonable accommodation is not necessarily the accommodation that the employee asks for. they're entitled to something that's reasonable, not necessarily the accommodation of their choice. As I mentioned before, you rely on the undue hardship exception to simply deny at your own peril. One thing that employees often get wrong, and so it's worth telling you as employers, is that accommodations cannot be used to excuse an employee from behavior standards. If an employee has, and I'll use an extreme example, if an employee has borderline personality disorder, something like that, um, and the way it manifests in them is that uh, they explode in bursts of anger at people. You need not excuse as an accommodation exploding in bursts of anger at employees in the workplace. You might need to you might need to give them an accommodation so they can go get treatment. You might need to modify work schedules. You might need to give them remote work at some points, but you don't have to tolerate misbehavior, even if it's a result of the accommodation request. Before we go on, let me just add a little footnote there. As a mental health advocate, I use the example of borderline personality disorder, but one of the big ways that employers make mistakes is by stereotyping employees based on their disabilities, their mental health conditions, making assumptions that because somebody has a physical or increasingly an emotional health condition, that they are going to behave inappropriately or that they're not going to be able to do the job well. Treat people as individuals. That is, and their abilities, not based on their medical diagnoses. That is the core command of the ADA. So let me mention some core mistakes that people make in the ADA context, and then we'll finish up on retaliation real quick. The first is ignoring requests, right? Requiring those magic words. As I said, there are no magic words. You need to be on the lookout for if somebody is making a direct or an implied request for accommodation, or whether you become aware of a situation where someone needs an accommodation. The second, and this is the biggest one, I think, is assuming that if an employee is out of FMLA leave, or if you are too small an employer to offer FMLA leave, that the employee is not entitled to any leave at all. That is not the case. The ADA commonly requires medical leave as a reasonable accommodation, even where the FMLA does not apply. I can't stress this enough because it's one of the biggest issues that we see in ADA cases. So let's, if there was a question, I can hit that real quick.
Yeah, Matt, there was a question. What if the employee gets a doctor's note to support the accommodation of their choosing? Does that need to be honored? For example, remote work.
Remote work is a hotly litigated one. The answer is it depends on whether there is another reasonable accommodation that would allow the employee to perform the essential functions of their job. Sometimes there might be, and sometimes there won't be. If there isn't, then you've identified the only reasonable accommodation and you have to give it unless it would pose an undue hardship. Hope that answers the question. There are scenarios where if the doctor hasn't given enough information, you can seek clarifying information or even get a second opinion. We don't have time to cover that right now. You should call Jennifer about that.
And then
Tourette syndrome, I see that one. So
Yeah.
Tourette syndrome, you do not have to accommodate behavior standards. And so if someone's Tourette syndrome, if the way it manifests in them is that they are using out of their control, even if out of their control, right? No malice. If they're using the N-word or other slurs, because that's how their Tourette syndrome manifests, you don't have to accommodate that. You should talk to a lawyer because that's a dicey situation. And now you're in a situation where you're talking about different employees' employment rights butting against each other. But that's a general rule.
And then Matt, one other question. Uh, once you've gone through the interactive process and you've approved of accommodations, you've come to an agreement on what the accommodation will be, is that a forever thing? Is that indefinite? Are you allowed to revisit that every 90 days, every quarter, every 6 months? How would you
Yeah.
recommend an employer handle that?
So as with all good employment and legal questions, the answer is it depends. It depends on the uh, nature of the accommodation and the need for it, whether that changes. It can also depend on if things about the business and business operations change. That might, in some cases, tip the balance about whether something's an undue hardship or reasonable accommodation. So retaliation, we talked about it a little bit already, so I can skip through some of this, but in general, employment discrimination laws prohibit employers from taking negative job action against employees because they've engaged in protected activity. As Claire said, that's things like making a discrimination complaint, filing a charge of discrimination, suing. It also includes being a third party witness in an investigation involving other people. That's protected activity. And then adverse actions, right? Prohibited things you can't do if somebody has engaged in protected activity. Obviously, fire them because of it. Demotion, reducing their hours, transfer to less favorable job circumstances. The standard is basically anything that a reasonable person might be, that might dissuade a reasonable person from engaging in protected activity in the future. And that leads to lawsuits, right? As we said, it's one of the most common, if not the most common claim. And these claims, retaliation claims, are frequently stronger than the underlying discrimination claim. There are plenty of situations where the underlying complaint of, say, sexual harassment ends up being without merit, but the retaliation claim is what puts the employer on the hook. So let me just give you some critical reminders about retaliation, sort of in a nutshell summary. The first is that employers may not retaliate against an employee even if they are wrong. To be protected, the employee's complaint or protected activity need only be made in good faith. If an employee complains of age discrimination in good faith, but they are wrong, you still can't fire them because they made a complaint that was wrong. And if you think that doesn't happen, you are wrong. I have had that case. I've had that. And remember, employees increasingly record HR and termination meetings. I had a case years ago where an employee had a sense they were about to be fired for reporting a safety violation. They recorded it, and the employer said, "We investigated your complaint. We found it without merit. We don't take kindly to that sort of thing, and you're fired." And that employer was held liable. So the next is, as I said, transferring employees to get them away from the harasser, but the transfer is less desirable. That could be considered retaliatory. If you're not transferring, if you're not separating the accuser from the accused, you got to remind that manager, that supervisor, that they need to treat the complaining employee the same as everyone else. And before they're going to discipline them, they better check with HR first. And lastly, temporal proximity is critical. That's a legal term for the amount of time that passes between the protected activity and the adverse action. The closer in time, the temporal proximity, the greater your chances of legal exposure, and certainly the greater chances that you're going to get sued. That's a lot in a little bit of time, but I'm sure all of us are happy to answer your questions now or later. And again, thank you all so much for being here and being part of the CMBA community.
Sam, you go ahead. I mean, we've run a little over, but I'm sure people have more questions.
Sure, thank you. I want to begin by thanking our panelists and our moderator today, all of you at home. The CMBA team did a tremendous amount of work to help us pivot from an in-person to a virtual event in less than 24 hours due to the inclement weather. I want to thank Nonprofit Legal Resource Center's funders, the Greater Cleveland Funders Collaborative. Encourage folks to watch our website because we will be posting this video and sharing the slides there. I'll try to also get those out to everyone who registered for the event. I would also like to put a plug that we will be doing another event on March 19th. It's a Thursday that will hopefully be in person at CMBA from 9 to 10, where we'll hear from experts Patrick Britton and Fran DiDonato concerning grant interpretation and compliance matters. If there are no additional questions at this time, mindful that nonprofit leaders as well as our panelists and moderator carry a lot of responsibilities. I'll end the call, but I thank you so much for joining us and look forward to connecting with you in the future. Please feel free to reach out to the Nonprofit Legal Resource Center if there's anything that I or those who support us can do to support you. We love helping the helpers. Thank you again to our panelists and moderator. Appreciate you.